Hi everyone, my name is Muzeng Huang, a student from the United Kingdom, and today I will be talking about my paper titled Artificial Intelligence in Legal Systems, examining gender bias and the role of UK legal frameworks in addressing it. And now I will share my screen. So this is the cover slide. So, with the proliferation of AI systems, more and more of these tools are being utilized and embedded in the legal system that have legal or similarly significant effects on individuals. Unfortunately, the gender discrimination prevalent in the justice system has been replicated and carried forward by these AI systems, which is an urgent and major concern for the society. My research paper introduces and analyzes three types of these AI algorithms being used in the legal system, how and why they exemplify gender discrimination. I then look into how the current policies in the UK specifically are addressing these AI gender discrimination, specifically focusing on UK GDPR and its proposed changes. And lastly, I will talk about my recommendations that will help not only react, but prevent these gender biases. So, first of all, I will be talking about risk assessment tools. These tools are used to assist judges, prosecutors, and other legal professionals to predict the probability of certain outcomes in courts. Since these tools work by analyzing historical datasets and identifying patterns, the quality of the dataset is important. This then leads to two problems. The first problem is the underrepresentation and the lack of analyzed data of certain groups, such as female. This means that risk assessment tools have been male-centric as they over-rely on male data, which then leads to inaccurate assessment outcomes for women and other gender identities. And the second problem is risk assessment tools' disproportionate focus on demographic features, a general problem that also disproportionately impacts women negatively. For example, women with socioeconomically marginalized status may be subjected to longer custodial sentences and less favorable treatment in the legal system. Now, since the inclusion of gender as a variable in the risk assessment tools has led to such inaccurate and biased results, scholars have tried to completely omit gender as a variable in the risk assessment tools. However, risk assessment results are still inaccurate when gender is not considered as a variable, specifically in a way that overestimates the risk of recidivism for women. Therefore, when thinking about omitting gender completely in the risk assessment tools to ensure fairness, this direction is wrong. Instead, the correct direction would be to develop gender-specific risk assessment tools while not treating protected characteristics as decisive factors for prediction outcomes. To expand on what I mean by gender-specific risk assessment tools, this would mean taking into account gender-specific experiences and including a wider diversity of datasets for the risk assessment tools, as currently the majority of the risk assessment tools now available for violent extremist offenders are majorly designed to evaluate male experiences and behaviors. Now, moving on, the second type of AI tool I will be talking about are facial recognition tools. In the legal system, these tools enable biometric identification and categorization. How this tool works is that biometric identification requires a database of known faces to match against, allowing police and security agencies to identify suspects, and they assist in criminal investigations as well. However, these facial recognition tools are also disproportionately bad at identifying darker skinned females. This then results in false positives, where individuals are wrongly identified as suspects in the legal system. For instance, Portia Woodruff, a pregnant woman falsely accused of carjacking, was the first known female victim of this phenomenon. She was held for 11 hours and experienced severe physical distress, including a panic attack, and she was later hospitalized for dehydration after the charges. Moreover, this is not a unique case, and many women are suffering due to the lack of historical datasets to correctly identify their identities. And just a side note, the image shows a documentary called The Coded Bias, which is a documentary that addresses the biases found in facial recognition technology as well as other AI systems. And moving on, the last type of AI algorithm I'll be introducing are automated decision support and decision-making tools. According to the UK's Information Commissioner's Office, also known as ICO, automated decision-making is the process of deciding through automated means without any human involvement. Again, for decision-making tools, major sources of gender bias comes from biased historical data, underrepresentation, and the lack of gender diversity within the AI development teams. Many of these decisions can cause harm to women, as scholars described as algorithmic violence. An example is recruitment AI algorithm that Amazon developed in 2014 that majorly favored male candidates. What happened was that these algorithms simply served as a proxy for humans and discriminated against female applicants for technical roles, like how most HRs would in real life. And if used on a wide scale without adjustments, this would significantly limit women's job opportunities and financial independence. Other examples include Facebook job advertisements favoring male candidates for STEM jobs, credit loan algorithms demonstrating gender bias, and demographic biases in custody decision-making algorithms, which standardize judgments on unique family disputes. So now moving on to policy analysis. The most relevant policy in the UK that is being used to address gender discrimination in AI systems used in the legal system is the UK GDPR. Specifically, Article 22 offers safeguards aimed at protecting people from potentially harmful AI decisions. Article 22 gives people the right not to be subject to solely automated decisions which have a legal or similarly significant effect on them. Moreover, Article 22 of the UK GDPR grants individuals the right to contest decisions that have legal or similarly significant effects on them. In general, Article 22 emphasizes communication, accountability, and transparency. Nevertheless, there are still a few limitations of the UK GDPR. Firstly, the UK GDPR framework only serves as a reactive mechanism when there is a legal or similarly significant effect, rather than preventing biases from arising in the first place. This means that it is only preventing AI decisions from being legitimate if they are believed to be biased, whereas other AI systems in the UK that exemplify AI biases might not be thoroughly regulated if they do not yield a legal or similarly significant impact on individuals. However, sometimes these subtle biases can also have very powerful and they are subconscious nudges, even though they may not immediately change behaviors. Therefore, it is crucial to eradicate these biases from happening in the first place. And secondly, there is nothing from the UK GDPR that explicitly aims at protecting against gender discrimination in AI algorithms. And moving on to the proposed Data Protection and Digital Information Bill, which is a legislative proposal that seeks to update the UK GDPR, introduced in the UK Parliament during the 2022 to 23 session, but did not complete its legislative process. The general aim of the DPDI bill is to adjust the UK GDPR into a more business-friendly and deregulated framework, which may weaken some of the protections currently offered by the UK GDPR. So, in general, the DPDI bill aims to simplify compliance requirements to create more flexibility for businesses. Even though the UK government ultimately decided not to proceed with this bill, it still signals this future direction in which the UK government is attempting to sort of balance innovation with the rights of data subjects. However, as this trend continues, the crucial step of eradicating the root causes of AI-generated discrimination remains absent. And therefore, I have proposed a preventive measure to stop biases from arising in the first place. And in order for this to work properly, there should be a development of a robust legal framework that clearly outlines the obligations across three key stakeholders. So the policymakers, companies, and users. To summarize my recommendations for obligations across these stakeholders, firstly, policymakers should create specific bias-aware frameworks for corporations developing AI algorithms used in the justice system. Raise awareness of potential AI biases and set up independent bias oversight committees responsible for reviewing and addressing these biases. And secondly, companies that develop AI should comply with government frameworks, conduct bias impact assessments before full deployment, and should be held accountable for damages and penalties if biases are identified to be caused by their AI systems. And lastly, end users need to be aware of potential biases, report them to the committee I've mentioned before, and have the right to contest and comprehend AI decisions. So, to conclude, AI is a tool with immense potential both for revolutionizing our justice system and carrying on our previous biases. And this is an urgent matter that we have to be aware of its biases and that policymakers should introduce preventive measures to prevent AI biases from prevailing. AI is our opportunity. If AI algorithms deployed in the legal system can be designed and implemented with minimal bias, this awareness could lead to a revolutionary transformation in our society where justice is free from discrimination. Thank you for listening.